Hey everyone, I'm Emeka coming at you here from my self-publishing Blueprint and the Blueprint Publishing Academy, and I'm sitting down with Kaylee Jacome from Brand
Law Boutique.
From Brand Law Boutique, and she is a trademark lawyer, and we're going to talk about all legal things. Well, as much as we can talk about today for the channel. So, Kaylee, welcome to the channel.
Hey, Emeka, how are you?
I am doing good. I'm doing good. So, because this is a very, very different topic than what we've talked about before. And just talking with you off camera, there's a lot of things that I didn't even know that really we should be thinking about.
There is. And you know, your videos are always really motivating and entertaining. So I'm going to do my best to make the law as exciting as it is, but as it can be, but you know.
So you got a list of questions. So let's start with those, and we'll just kind of, keep hammering through stuff. I think you want to put a little disclaimer up.
Yeah, so I hope this content is helpful to everyone, but I'm a lawyer, but I'm not your lawyer. I'm not the lawyer of anyone viewing this unless you've executed an engagement agreement with me. So this information is not legal advice. It doesn't apply to anyone's specific situation. It is just educational information. And for your specific circumstances, you should consult an attorney licensed in your jurisdiction.
Awesome. All right. Now that we got that out of the way, let's dive into things. We're going to talk about, well, it's going to be a lot publishing focused. I know one of the big topics everybody wants to know about is like, should you start an LLC? So we're going to get to that.
Okay.
But let's go through it. And I think we're going to try to make this some fun. So
let me ask you. How have you heard people talk about the word copyright?
I know there was somebody in the group who was always like, copyright and trademark are two very different things. I always thought they were the same thing.
So sometimes you hear people say, can I or should I copyright my book? Or he copyrighted my book, like it's an accusation.
Right.
Or like she copyrighted my idea. And all of those things are a total misuse of the word copyright. It's not a verb. Copyright is a legal protection. And so I should also say that everything I'm going to talk about today is US law. So, copyright protection is pretty similar in the EU and Canada and in many places around the world, but the specifics of what I'm talking about is US law. So it's a legal protection that's extended to an original work of authorship that's in a tangible, fixed medium. You don't copyright your book. You have a copyright to the material of your book. You have a legal protection. Someone doesn't copyright your book. They commit copyright infringement. A couple of requirements of it. It needs to be in a tangible medium. So even if you don't publish anything, when you type a document on your computer, you have a copyright to that. You have a legal right to the Word document that you just create. It's original. But if you're like in the shower planning your manuscript and you're just like speaking this out into the world and it's not recorded, then you don't have a copyright to it because it is not in a tangible medium. If you had recorded that, that would be a different story. So that's what copyright is. Yeah. And so registering your copyright, if someone says like, how do I copyright my book? What they mean to say is, should I, or how do I register my copyright?
Yeah.
You actually have a legal right to your book or to anything you write the moment you create it. So you don't need to register. There's no requirement that you register.
When I publish a book, right, that I didn't write, like a ghostwriter wrote, but let's just, say for the sake, I have all the rights. So I don't have to go ahead and like protect that so somebody else can't take that information and like publish it or like.
So you don't have to. If you decide to, then they're going to, and I'll go over a couple benefits to doing that. But if you don't register your copyright, but you publish it and then someone copies that and sells it as their own, or reproduces it in some way, they still committed copyright infringement, even if you didn't register it.
Now, is it the exact like verbatim word for word, or what if they just kind of, flip it around?
Now we're getting into the weeds, and this is like the weeds of why my profession exists. So there's no clear-cut rule about that. In general, copyright law says that like a slogan or a short phrase is not copyrightable. That's actually possibly trademarkable, but that's a whole other situation, and a whole other set of requirements. But there's no minimum amount of words. So it's, there's been litigation over 10 words. It just comes down to whether you are, whether you're stealing someone's expression of an idea. The shorter the amount of the amount of words that are being copied, the harder the case is, for arguing that they're committing copyright infringement, because they could have, independently put these words together.
So let's talk about publishers and how to protect our business, because, let's, a book starts doing $1,000 a month. Mm-hmm. Right? that starts to become some serious income for that one asset.
Yeah.
Like, should we be concerned about protecting that?
I would definitely say so, especially since the filing fees for registering your copyright are very cheap. They're $35, to file, to register your copyright. It doesn't take that much time. You can file it online electronically. And so there are a couple benefits that I'm going to go through. So first of all, when you register, you're going to get, if it's approved, you're going to get a certificate of registration. And that makes it easier for you to establish in the event of a dispute that you are the author, that you own this copyright. You have this certificate. So that's going to be prima facie evidence in court, So what that does is it flips it. So when you have your certificate of registration, it flips the burden of proof onto the defendant. So you're like, here's my certificate of registration. The US Copyright Office says that I own this. And so now it's your burden to prove that I don't. Your burden to prove that this certificate is not valid, or I shouldn't own the rights.
One of the things that they can do, or they'll send an email out saying, hey, we want to just ensure that you own all the rights to this book, this title, right? Mm-hmm. Usually it's a pretty smooth process. You just send back, I wrote the book myself, I'm the author, I use a pen name, thanks for watching out for me. And like 95% of the time, you're good to go. Mm-hmm. But sometimes, and albeit I'm not reading these, every student's email, because usually they screw this up, even though it's literally what I just said to do. Amazon denies them, and they want actual proof. So with this letter, this would basically prove that you own the copyrights to that particular book. Yes.
It proves that the U.S. government, through their copyright office, has recognized you as the lawyer. Has recognized you. The lawyer, sorry, has recognized you as the owner of that copyright. Now, at the end of the day, Amazon is a private company, and your relationship with Amazon as a self-publisher, a lot of what I'm talking about is, copyright law as it exists outside of the world of Amazon, and is actually greater than Amazon themselves, though few things are, right? Within Amazon, that's their platform. So
they can kind of
I can't say that every single time they're going to take a certificate of registration as bulletproof evidence.
Yeah.
That's their decision.
Okay. Like another scenario is like when somebody files a third-party trademark against one of your books, and they say, hey, you don't have permission to use this. Mm-hmm.
And you're talking about through Amazon's internal channels.
Through Amazon's internal channels, they, just like Minecraft, for example. So they might file as like, hey, this person's using this name without permission. Now, the crappy thing is anybody can do that with like anything. And
because it's they're doing their due diligence, they have more of a stake in not having people be committing copyright infringement on their platform than they have a stake in you being able to sell your book, whether it's valid or not.
So, okay. And so with this type of letter or certificate, but you said it's hard to tell because Amazon plays by Amazon's rules.
Right. So, they're entitled to, they have no legal obligation to you to recognize that.
100%.
But, so I don't want to say my feeling is I can't imagine why they wouldn't take a certificate of registration from the U.S. Copyright Office as proof of your ownership. But that's their prerogative.
Right. Yeah, no, it makes sense. And yes, no, dealing with Amazon sometimes is extremely difficult and frustrating when stuff like this happens. But okay.
And then I would just say also though, when you're starting or running a self-publishing business, that's your business. And because Amazon has created such an awesome platform that enables us to do these things online, it can feel like Amazon is God, but they're not. And that's still your book. You still own that. And even if they take it down, you can go sell it at the farmer's market, that. No one can take that away from you.
Yeah. Okay. No, 100%. No.
And that's important, I think, to, that I'm sure they're not going to be replaced anytime soon, but, as other platforms or competitors emerge, when you write a book and you're the author, you own that copyright, that's yours. Just like someone can't take your education away from you. Someone can't take your book away from you.
Yep.
Another benefit of registering your copyright is if you do so within 3 months of publishing it. So you publish it on Amazon, within 3 months, you register the copyright. If it comes up that, if you end up in court over a copyright infringement case, which is probably not going to happen. You would have had to probably do really well in your sales to justify that, right?
That.
But hypothetically, that enables you to recover statutory damages. So, so monetary damages that are, statutorily provided, and attorney's fees. So if you win your case, then the party that committed copyright infringement against you has to pay all of your attorney's fees.
This could be a lot. I could see how this would be a lot more relatable for fiction publishers.
Okay, right.
Because they're writing a story.
Right.
What you're describing, I've heard it happen a lot more often in fiction than nonfiction, because it's like, oh, this person wrote this story. And then, unfortunately, the ghostwriter just kind of took a story from somebody else and just, changed a few characteristics.
I think one question that might come up, especially in the situation that you just described, is, can I protect my characters? Are my characters copyrightable? And not just, because we think of copyright as like almost synonymous to plagiarism, but it's more than that too. And so the short answer to that is usually characters are not copyrightable unless they've become so descriptive.
Harry Potter.
Right. The more detail, the more basis you're going to have in protection.
A few other benefits you want to go through?
Sure. Yeah. We talked about if you register within 3 months, then you're going to be able to, recover your fees and damages. If you register within 5 years, that's when your certificate of registration is going to be prima facie evidence in court and switch that burden to the defendant. So if for that benefit, you need to get that done within 5 years.
Within 5 years.
Publishing your book. Yeah.
The next point you wanted to
So I think a lot of people are starting, you have your ebook, you have your print book, and then audio book. Audio sales are huge.
Massive.
If you are going to register your copyright, you only need to submit one application to cover your ebook and your print, but you're going to need to file a separate application for your audio as a sound recording. Yeah. So it's not, it's going to be an additional $35 and probably, 30 more minutes of your time, but that will require 2 separate.
Okay.
Huh. I think you kind of touched on ghostwriters.
Because so here's what people are doing right now. Most people, including myself. hire a ghostwriter, right? They'll go to Upwork and they'll hire a ghostwriter, have them write the book, and then pay them. And I think I started a contract maybe once, but then I was like, whatever, who cares? And I just didn't bother. And so, I'll be the first to admit, I'm not telling any students to do contracts for ghostwriters or anything like that. Now I tell them to do a writing company, put more of the burden on the writing company versus because they're hiring their ghostwriters.
Okay.
And you pay the writing company.
I just want to comment. I don't have experience with writing companies.
Right.
So everything that I'm about to discuss may or may not be an issue depending on your contract with that writing company.
Correct.
So that's why you should read the legalese, because you may be like SOL on what I'm about to say, or you might be completely covered.
Completely fine. All
right, I don't know.
Just working with a freelancer.
So we're going to talk about is if you if you went on Fiverr, you went on Upwork, you hired a freelancer ghostwriter. That's kind of
anybody watching my videos is smarter to ever go on Fiverr for writers.
I think when you think of ghostwriter, there are two common misconceptions. And the first one is you wrote it, but I own it. Okay. And the second misconception is you're a ghostwriter, you're invisible, nobody knows about you, you didn't really do this, I wrote this, I labored over this, thank you and goodbye. And the law does not assume either of those. It's actually the opposite on both points. So legally speaking, unless certain things are in place that we're going to get into briefly, when a freelancer, even if you hire them to write, you go on Upwork, you hire a freelancer, you say, will you write me 50,000 words on this topic? And they send it to you and you pay them.
Yeah.
Absent anything else, they own the copyright. You
for how long? Forever?
Copyright. And this is why. So the owner of a copyright is the author. They are the author. There's an exception to that, and it's called the work for hire. And so you might be listening, if you're still listening, if I haven't bored you enough yet. Work for hire. Well, I hired you to do this work, so that's the work for hire exception. But it's not that simple. It's either they're your employee and then that qualifies, so they're on your payroll, which I highly doubt most people are doing, especially if they're starting out in self-publishing.
Correct.
Or you have a written signed agreement with them, so your messages back and forth on Upwork are not just that, that evidence even of that transaction is not an express written agreement that it's a work for hire situation, and it's certainly not signed by you, right? I've never signed anything, it's, even though you have your profile picture up, that's not a signature. And then furthermore, to make it even worse for everyone, there are 9 categories, and you can go on, I won't bore you, and you can read the 9 categories that the work must fall under in order to be considered a work for hire. And to be honest, I think a lot of people would be surprised. Many of the books that self-publishers are publishing are not going to fall under that. So like if you are writing about like how to brew the best latte, that's not going to probably fall under one of these 9 categories. We'll go through them briefly. So think of, have in your mind the books that you want to write or that you've written. And as I go through them, think if they fall
if they'll fit in there. Okay, cool. Worst case scenario. I have a book on how to meditate and whatever. So how to meditate. I didn't sign a contract with my writer because, whatever, who cares? All of a sudden, this one book starts doing $2,000-$3,000 a month.
So they can reproduce that. They own that. So they own that, not me.
Even though I published it.
They can publish it themselves. And if you guys get into a dispute because you're saying, oh, you're infringing on my copyright, this is my book. Actually, it's not. Actually, it belongs to them. Actually, you are the copyright infringer. So
could they come after me and take my money? Like take the money that book's making?
Yeah, potentially.
Like that's worst case scenario?
Yeah, that's the worst case scenario. And so especially if you're doing high volume sales.
That's what I mean.
And I mean, if people are thinking right now, I really trust my freelancer, I don't think that they would ever do that, or, or whatever it is. first of all, you should be concerned about owning your copyright, because at the end of the day, let's say you have a dispute about their fee, or let's say they did a really crappy job and you don't like their work. You can deal with those things, like that can be
That's
dealt
easy
with.
to fix on
But
Upwork,
if you don't own your copyright and you're a self-publisher, that's a big problem. That's a really big deal, because you are making your money, your business is based on the ability to reproduce, publish, and distribute. And effectively, you don't have the right to do what your business is based on.
And this costs $35 to protect yourself.
Right, but that's to register. But what we're talking about right now, you would actually not qualify to register your copyright in this situation, because it doesn't belong to you. So the step we're at right now is before it's ever been created. And you really want to have an agreement in place. And
so that ghostwriter agreement.
Yeah, and just like anything, it's one of those like pesky parts of business that isn't fun to do, like the privacy policy on your website. Like no one wants to sit down and write that, but it's something that wouldn't take a long time, to put together, or have someone else put together for you. And, as a lawyer, I'm going to suggest that you seek legal advice in putting together an agreement. And then you can plug and play. So you can you can use that as a template where you change the details.
Ghostwriter agreement is something everyone should be using when they're working with a ghostwriter. That,
if it's a work for hire, I think it would be important for a lot of people to have that express language. We agree. I won't give template, boilerplate language, but we agree to this. We agree this is work for hire, and you're both signing it. It wouldn't be bad to protect yourself even further in case it's later found that you don't fall into the one of the 9 categories, or let's say you already know you don't. You just have one simple fiction novel, so you know that it's not falling under one of the categories. You can have a clause in your agreement that says that the writer agrees to transfer and assign the copyright to you. And when you both sign that, that means that you own the copyright. So you've bypassed this whole issue.
Interesting.
Yes. The other big thing, ghostwriter, thinking that they're invisible, they're not going to come out of the woodwork. That's another clause that you want in your ghostwriter agreement, is a non-disclosure agreement.
Right.
That they are going to keep the details of the project confidential, so that when you have a bestseller, they're not going to come out of the woodwork and say, like, actually, I wrote that, that's mine, because there's nothing that stops them from doing that. Even if you own the copyright, they can still say, I was hired to write this. I wrote this, as per our agreement. There's nothing that stops them from doing that. And that's obviously really bad for publicity, for your reputation.
All right. What else you got here for us?
So a couple other, so if you're convinced that you need a written agreement, a couple other things that would be useful to include is scope of services. Is just a fancy way of saying what are the details of the project that you're commissioning. So lay it out so you don't have a disagreement about it. And then and payment, and there may be other clauses that you want to include, but those are the important ones.
Cool.
So,
all right, man.
Yeah.
All right. That was good. That's good.
Let's say despite all of your efforts to protect your work, you see that someone is infringing on your work. Someone has, has posted that. So you have avenues within Amazon and avenues outside Amazon. Okay. You are probably more familiar than I with the avenues within Amazon.
Yeah.
And, it's kind of a situation where if you are publishing on Amazon, their policies are going to be in some ways more relevant to your life than copyright law, because that's the controlling relationship there. And so, as you probably know, you can file a notice of infringement, file a complaint with them. And it's pretty easy to do that. And so you need to deal with Amazon through those internal channels. But that's not your only recourse. And, there's a world outside of Amazon. And outside of Amazon, what you would do if you saw someone infringing on your work is you would send them a cease and desist letter. You've probably heard of that.
Yeah.
And so,
So is this stuff you do?
What's that?
Do you do this?
I've done that. I have done this in the past. Right now, I'm focusing most of my practice on trademark law, but I used to practice both copyright and trademark law.
Okay, remind me to talk to you about something after.
Okay.
Okay.
So
All right.
so cease and desist letters. You know, they come in many shapes and sizes, but you're gonna want two main things in them, and that's a detailed description of the
Yeah.
offending behavior.
Okay.
So, you know, that you own this copyright and exactly how they've violated your rights. And then in that letter, you also want to make a demand that they cease and desist, that they stop and they not continue it. And so there's no legal requirement to send this letter, but it puts them on notice, you know, that they're, in case they didn't know that they stole your work, now they know.
Right.
And it's, you know, it's a much more cost-effective way of potentially getting them to stop the infringement than filing a lawsuit.
Right.
The next step would be to file a lawsuit. And you can file a lawsuit even if you didn't send a cease and desist letter. But, you know, but it's a good first step to take.
Okay.
So if you find yourself in that situation, you should consult a copyright lawyer in your jurisdiction.
Okay. All right. No, that's cool. That's cool. What are some of the other topics you wanted to cover there?
Let's see. So trademark, we talked about how sometimes people confuse copyright and trademark.
Yes.
And some people ask, can I trademark my book title?
I'm going to go with no.
You would be correct. You cannot, but usually not. There are exceptions to this. Usually not.
There seems to be exceptions with every law.
Yeah. You know, the reason for that is that lawyers or people who legislate law tend to have a legal background, and they just want to keep their profession alive and keep people like me in business. So they just make it really complicated so you can't navigate it.
Okay.
That's my theory. And so you can trademark a book title if it's a title in a series.
Like something like yoga for beginners. Can I trademark that?
So it depends. I mean, it would need to be a series.
So I create 5 books. Yoga for beginners.
I would say I'm not giving legal advice to the person who has the title, but if your work is considered a series, then you're gonna fall under that exception. And there's another exception too. So what trademark is it identifies goods and services and the source of those goods and services. So let's say you have a book title that is your brand, it's just your brand name.
Right.
And you have a book and it's the title of your book, but you also have t-shirts and you also have, like, I don't know, whatever else. Yeah, hats. So you can absolutely, you know, provided it fills the requirements of trademark law, you know, in every other way, you can trademark that in connection with the hats, in connection with the shirts. You just can't trademark something in connection with a book unless it's a series.
Wow. Okay. All right. That makes sense.
Yep.
Okay. So
and the reason for that is you can't copyright something or you can't trademark something if it's generic and just descriptive, and the law assumes that book titles are generic and descriptive. They're not necessarily so, but it just assumes that.
Right. Yeah. Okay. What about LLC? This will be the last topic we talk about today.
So this is a big question. So if you're just starting out, or maybe you've been running your self-publishing business for a while and you've been running it as a sole proprietor, and you're wondering whether you should form an LLC. Typically, and that's the most, you know, there are other business forms, but usually you're choosing between the sole proprietorship and the LLC. And so the decision of whether to register an LLC comes down to an assessment of your tax liability and your legal liability, your legal risk. So the tax liability, I'm not going to get into. I'm not a tax expert. You can, you know, interview a CPA, can get into those weeds next time. But as it relates to legal risk, you need to look at your business and think about all the ways that you could be sued. Because if you're a sole proprietor it just means that you're, usually you're operating under your social security number. You can apply for an EIN as a sole prop, but you're just an individual. And so there's all of your income is personal income. It's taxed as personal income.
So they're coming after you.
They're coming after you personally, and you have no asset protection in that structure. You don't need to register. You don't need to do anything to become a sole proprietorship. It's an automatic form. You start selling your sole prop. There are, depending on your state, there may be a requirement to register, but that doesn't make you a sole prop. It just makes you a sole prop that is complying with the laws in your state.
Okay.
And so the decision to become an LLC, besides tax issues, is that your personal assets are going to be protected if you are sued. So you are only liable up to your investment in the company. So the money that you've invested into the company that now becomes the property of your LLC. And if you're sued, they can get those assets, but they can't get your home. They can't get your personal car. And so that is a really serious advantage for some people, depending on your business or your liability risk. So as it relates to self-publishers, you don't have a brick and mortar. You don't have a place of business where people are coming and potentially, slipping and falling and suing you because they broke their neck. So that's not really an issue.
But it's more
really,
like if you're
go ahead.
If you're using somebody's name, write somebody's name, like a big company's name. They're like, hey, you can't be doing that. And then they come after you. Like that would be the only implication that I could really think of for publishers, right?
Right. So for self-publishers, the main, maybe not the only, we could sit here and think of other potential areas, but it's
with other ones.
It's mostly going to be intellectual property.
Right.
So intellectual property, as it relates to self-publishing, is your copyright and your trademarks.
Right.
So that's going to be your main area of exposure. So it's all about your exposure to being sued, the exposure to your personal assets. And so especially if you're hiring ghostwriters, you need to be doing your due diligence. So not just assuming that this wasn't plagiarized.
Right.
It's ultimately on you. Even if you hired a writing company, again, I haven't read your contract, but you can't rely on them either, because ultimately after it passes to you, you are the one who is distributing this. And so you need to do your due diligence that you're not putting plagiarized material out there. So that's one thing. I think as your business grows, people are in self-publishing for different reasons.
Yeah.
Maybe you're just putting books out there, or maybe you have a larger brand. So maybe this is like a lead magnet to other services you provide, or maybe you're a coach, whatever it is. Then, your business model is bigger. And so then you get into other areas of potential liability. So the coaching example, misrepresentation, breach of contract, these are additional areas of potential liability exposure that an LLC could potentially, be protection for you.
You don't set up LLCs or that type of stuff for people
in New Jersey, if you are setting up an LLC in New Jersey.
Awesome. Well, I know we're going to do another part of this, but we're going to go into more detail, and that will be inside. That'll be closed for members only. But we're going to go into more detail of some of the more specific topics that we touched on today. But thank you so much. Your book should be out by the time we do this interview.
Yeah, so it will be.
I'll have a link below. So if you want more information about, what's your book about? Why don't you?
So it's called Brand Law. The name of my law firm is Brand Law Boutique, and the book is Brand Law, and it's a guide for entrepreneurs starting and running their business. So, I think one of the difficulties when you're just starting out is you don't know what you don't know. And so you can, try to do your own research. What I've tried to do is really bring together the basics of what you need to know. So how to choose what entity to register your business as, how to protect your intellectual property, what contracts to have in place. And then at the end of the book, I go through industry specific guidelines. So some specific tips for coaches, some specific tips for subscription businesses, and just try to give a really useful overview for someone just starting out that maybe can't afford to hire an attorney to do everything for them. So again, it's not legal advice, it's educational material, but I hope it will be really useful to everyone.
And that should be good for no matter if you live in New Jersey, anywhere.
Right. It's US law. It's US law, but it applies to any state. Mm-hmm.
Yeah. So I figure if you get a good understanding of the US law, you're probably pretty good everywhere else, right? Like
it differs, but we tend to love legislation
right
here in the States.
Yeah, no, it's all good. Well, hey, thank you so much once again.
Thank you, Emeka.
Really appreciate this. This was fun. Hopefully it was not dry and boring like I found Law 11, everybody.
I know. Yeah, I hope not too. But sometimes you have a lot of inspiring content on your site, so they can go get excited somewhere else. And in this video, they can roll up their sleeves.
Right. It's the get dirty video, right? It's like stuff you don't. It's like what we talked about before before we started the whole trademarking, the course and everything. It's like, I've been trying to do this for a year. I just don't want to roll up my sleeves and do it. But now you've come, so I'm just going to hire you.
You're welcome.
Well, hey, thank you so much once again.
Thank you, Emeka.
Really appreciate this. This was fun. Awesome. Until next time.